afternoon. You can be seated. And the matter before the court is York 24-226, Pat Doe versus John Costin. Counsel are present. If I could ask that you identify yourselves for the record by saying your name together with the party you represent, starting with appellant.
Good afternoon, Your Honor. Scott Dolan from the law firm Petroselli, Martin Haddow, for the appellant John Costin.
Attorney Brittany Sawyer, representing the county's advocate.
Thank you. We are being streamed live, although I can see what you've got there. It doesn't look. Okay. We are being streamed live on the web, and both by audio and by video. And if counsel are ready to proceed, Attorney Dolan, I'd be happy to hear your argument.
May it please the court. Although this case presents multiple issues on appeal, I'd like to focus my protected time here on one critical question. That question is whether the law court's crystal clear precedent set in Casale versus Casale controls or remains binding precedent. Unless this court overturns Casale or creates a new significant exception to Casale, then that case gives a straightforward guidance for this appeal. Casale's holdings can be summarized in 5 key points. 1, filing a motion to modify in a protection case is akin to filing a new complaint. 2, the statute that allows for motions to modify requires that the court assessing such a motion must, and I quote, must conduct a testimonial hearing on whether any new circumstances require modification. And 3, there's no exception to the requirement that a testimonial hearing must be held to determine whether the moving party has met their burden. 4, granting a motion to modify without testimonial hearing is error significant enough to require reversal. And 5, further, it's not enough for the district court to rely on prior testimony from a prior hearing. The district court must conduct a new testimonial hearing. Here, the district court did exactly the opposite of what Casale requires. The district court declined to conduct a testimonial hearing on the plaintiff's motion to modify, and though the parties and witnesses were present in the courtroom, the plaintiffs agreed not to call any witnesses or present any evidence. Instead, the district court relied entirely on evidence from a prior trial to reach a different result than it had reached before based on the same evidence. Casale says that is reversible error, and Casale rests on rock-solid due process ground as guaranteed by both the state and federal constitutions. And for decades, this court has been consistent in protection cases like this one, that the defendant cannot be deprived of his or her fundamental liberty without the plaintiff having to prove the allegations at a testimonial hearing. The protection from harassment statute expressly requires a quote-unquote full hearing at which the plaintiff must prove the allegations. That is the same procedural standard as in protection from abuse cases. In Connolly versus Connolly, for example, the law court was emphatic about that point. And just as Maine law requires a testimonial hearing to be held on initial complaints, that is equally true in the context of motions to modify, where the plaintiff seeks to further deprive a defendant of his or her fundamental liberty. And this is a de novo review of whether the requirements of the protection statute were followed. And here, the district court's failure to conduct a testimonial hearing as required by the statute is reversible error. And with that, I'll answer any questions you may have.
Did you not agree to the process that was used on the motion to modify?
I consented that the plaintiffs declined to present any witnesses or present any evidence. It was a strategic decision. It was helpful for my client's case that they could not prove their case.
But did you not agree that the courts could decide a motion to modify based on that record that was given to it?
That, once the district court proposed and the plaintiffs accepted making offers of proof rather than conducting a testimonial hearing, there was only one way it could go. And that the motion could only be denied at that point. And the offer of proof approach did not relieve the plaintiffs of the burden.
But what you're really saying is the judge erred in the result, but you agreed to the process as it, when you start arguing with us that it had to be a testimonial hearing, that hearing was inadequate. That's not an issue that you raised below. You agreed to the process.
Well, this is a dangerous precedent we're talking about here. When a judge proposes that the due process requirements be waived and that there is no testimonial here, and if this is repeated at every trial court level,
Had you wanted a hearing, couldn't you have had one?
pardon me, Your Honor, I couldn't hear you.
Had you wanted a hearing, couldn't you have had one?
Yes, we could have.
Okay?
But I would point out that the basis of the plaintiff's motion to modify was that Mr. Costin took a copy of the district court's initial protection order.
And I understand that aside from the process that was used, you also don't think there was sufficient grounds
Correct.
to modify.
And that's
But
about to
I'm
dive in.
separating those two issues.
Understood. Nonetheless, it is the court's obligation to hear live testimony, evidence, to make a decision, and it can't be done otherwise. So when the court here agreed to take offers of proof with no testimony, there was no presentation of new circumstances that could require modification. The court relied only, and the findings of facts and conclusions of law bear this out,
So how were you prejudiced by this process?
that there was no basis for granting the motion to modify.
Well,
and
the
there-
process, the additional material was the fact that no trespass had expired. And how were you prejudiced by the fact that that was the evidence? What were you going to do had there been a live testimony? How would it change things?
What will change things is showing that there was, in fact, no change in circumstance. And instead, the judge sidestepped that crucial question, which is the very crux of the motion to modify.
Well, the change in circumstance was the fact that the directive was going to expire. Everybody knew it was going to expire on a certain date, right?
That was not a change in circumstance. That was a
Well, the
predestined
change is
conclusion.
not that it was going to. The change was that it had indeed expired. At the time of the first hearing, there was a no trespass order in effect, which might lead a judge to conclude that you don't need to have an order prohibiting the person from going on the premises. By the time the hearing came up for the motion to modify, there was no longer a no trespass order. It's a different issue to say that maybe you knew that was going to happen, but that is a change.
But it makes no sense. If the judge knew at the trial that it was going to expire on November, I forget the date, 16, 2023.
Wasn't there some discussion about whether they would be sought to be extended?
There was, not that I recall, Your Honor, no.
Okay.
And
Well, you say there was no, it doesn't make a difference. There was, at the time that the original protection order was issued, there were certain conditions that were placed in that order. After the motion to modify was filed, and after the expiration of the no trespass, there were different conditions put on. So to say that it was of no effect or no consequence seems to be
well,
missing something.
well, sure, the judge, based on the same evidence, the exact same evidence, first time he declined to check boxes E and F. Then he decided to check, or sorry, I should say, not he, the district court decided not to check boxes E and F. That's the same evidence, different result. Now-
Except that there was a no trespass order in effect at the first time, and there wasn't on the second.
Well, let's look at what actually the motion to modify actually says. It says that the conduct on which it is based is that Mr. Costin went to the assistant superintendent of schools and said, because the district court declined to issue a no trespass order, can you terminate your no trespass notice early by 2.5 months? And they said, well, no, we're going to let it expire as a natural course, and that's what happened. And by the time the hearing actually took place, you know, the hearing, not an evidentiary hearing, but the appearance of us counsel before the district court, that had already happened. It had been expired for months.
So the amended order in this case expired in June of 2024.
Correct.
Why isn't it moot?
The question of whether Mr. Costin owes money or doesn't owe money is not moot.
Okay.
And you can't get at that question without addressing whether the motion to modify was wrongly decided, because the statute by which attorney's fees can be granted, it depends upon whether the ruling was in favor of the plaintiff versus the defendant. And one of the kinds of relief that the district court can then give is attorney's fees, but it's conditional on the ruling on the motion to modify in the favor of the plaintiffs.
Are you contesting the amount of attorney's fees? In other words, if we were to find that it was justifiable to issue an attorney's fee award, are you also contesting the amount of the attorney's fees?
Certainly. The order itself does not specify what it is giving the award of attorney's fees for. Now, the billing was not made, I wasn't allowed to see that. That was all done in camera. But I would point out that the motion itself for attorney's fees, it doesn't specify, or sorry, it does specify expressly that it's seeking attorney's fees for both the initial trial and for the motion to modify. And it's worth pointing out that that can't be done. Rule 54, subsection B 2-3 requires that applications for attorney's fees be made within 60 days after the entry of a judgment. Now, the original 2023 protection order here was issued 191 days before the motion for attorney's fees was made. So it's 131 days too late. So unless we can
Let's
park-
say we agree with you about the absence of an evidentiary hearing. The transcript suggests that the judge didn't believe, the judge thought that the parties were proposing to proceed on offers of proof or summaries of their position. But let's say we agree with you, that would mean vacating the order on the motion to modify, vacating the attorney's fee award, and dismissing the case as moot?
It'd be reversing the order on the motion to modify, reversing the award of attorney's fees. And I'm also requesting that the motion to modify be deemed to have been frivolous, and then remand for award.
An award of attorney's fees in your client's favor?
Correct, Your Honor.
Okay.
If there's no further questions, I'll.
One of your alternative arguments was that allowing the modification infringed on your client's fundamental constitutional rights.
Yes, Your Honor.
Wish to elaborate on that?
Certainly. When a party uses the court to achieve some result, that is, in effect, a state action. And we've seen that done in cases like Lugar or Edwards versus Habib. Edwards versus Habib was in the setting of a tenant-landlord situation, where a landlord might use the court to infringe upon a tenant's rights, such as in tenants unions, for example.
Which constitutional right was infringed here?
It would be his First Amendment rights, or the analog under the state constitution, to go before the administrative body of RSU 21, which is the school district. There's two separate cases here, an administrative
Right to
case.
petition, you're talking about?
Pardon me?
Petition? Are you talking about the right to petition? What are you talking about?
Yes, Your Honor, your right to petition government for redress of wrongs. And in this case, it would be that the school department had a notice of no trespass issued to prevent Mr. Costin from going to the high school and other schools. And as a separate administrative case, as opposed to the court case that we're here for today. And by using the court system to try to block Mr. Costin from going through the administrative channels, which is his right, that is an infringement of his First Amendment rights through using the court as the hammer, so to speak. Now, and Mr. Costin did have some legitimate reasons for wanting to go to the school properties. Both Mr. Costin and his wife, who are in the courtroom today, are very involved in their community. And they have both served on boards and commissions for Kennebunk Municipal Government and for the school government.
Thank you, counsel. It appears that your time is up, so thank you.
Thank you, Your Honor.
Attorney Sawyer.
Good afternoon. May it please the court, Chief Justice Stanfill and members of the court. I just would like to address some of the points that the appellant made, specifically starting with the Casal case that he believes is crystal clear precedence and applicable in this matter. From our view, this case is not really on point with the case in front of the court today. That case was where a court had relied on evidence in a divorce hearing and making a determination on a motion. And that is not the case here. We're looking at a motion to modify within the protection from harassment case. It's a unified proceeding. It was in front of the same judge that initially heard the hearing, the 2-day hearing on the initial complaint. From our view, there was an agreed-upon procedure. Attorneys met in chambers with the judge that morning, decided how to proceed. There was an agreement to proceed by way of offers of proof and oral argument. The defendant did not object to that proceeding and waived a right to hearing that day. I also want to address the fact that the appellant indicates that there has to be a change in circumstance to prevail on a motion to modify, but that's not the exact language in the statute. The statute talks about modification as circumstances require, and from our view, there was a circumstance that required modification, as there was this new issue with the expiring no trespass order and the appellant trying to gain access to the high school where the children attended. There was a safety concern. The principal had testified at the original hearing that no trespassing order was probably going to remain in effect. That ultimately didn't happen, but there was a safety concern about the appellant continuing to be on campus. I also want to point out that the original conduct resulting in this complaint being brought forward had to do with the appellant following the children to their school, being on school property, blocking their vehicle in the student parking lot.
So, counsel, the green light is on. Can I circle you back to something you just said? You said that the statute doesn't say that there has to be a change in circumstances, but rather it's as circumstances require. Clearly, that is the statutory language, but doesn't that necessarily mean something must have changed?
I would say usually it does. Usually there's something that has happened.
I mean, you're really not, I thought your position was that something did change. There's no longer a no trespass law.
There was here, but there doesn't necessarily have to be a substantial change in circumstance. I think that's a term we use in family law
So
a
maybe
lot.
you're trying to not emphasize the substantial, but I mean, it just seems that to talk about as circumstances require to modify something almost necessarily requires that there's been some change, whether or not it's substantial.
Correct.
Okay. Can I also bring you to the issue of attorney's fees? I mean, you've argued, obviously, that the defendant can't at this point undo the original order, that obviously an appeal from that is long since expired. But isn't the flip side of that you can't get fees for the original process either?
Well, I think given that it's a unified proceeding, we had the right to ask for
Well,
that.
be careful. If it's that unified, can we go all the way back?
And that it was up to the court. The court had discretion. The court had the file to look through. They had our motion. There was multiple filings back and forth that the court reviewed.
The
and-
appellant
and
said
determined.
that the fee affidavit was reviewed in camera. Is that correct?
So the attachment with the outlining of our billing statements are provided in camera.
Isn't that usually just redacted? It's not completely made unavailable to the other side?
Normally in filing, we file them to be reviewed in camera, and there was no request to have a redacted version. It is not my standard practice to send a redacted version to opposing counsel.
Well, how does the other side then say, oh, you spent too many hours on conferencing? There's no way they can do that unless they see the affidavit showing your billing.
I think they could have made a request to the court to review that or ask for a redacted version, and that
Is
did
the
not occur
burden on
here.
them? You're the
Sorry.
one who's asking, is the burden on them? I mean, you're the one who's asking for the fees. Doesn't part of a request automatically mean that the other side has to have enough information upon which to base any opposition?
I think if they're concerned with the information that's provided, they can certainly file an objection or ask the court for further information.
Was there any objection to the amount of fees that were being asked for in this case?
I believe they did file a response objecting to fees in general. I don't believe there was any argument as to the specific fees, the number that was requested in the affidavit.
Notwithstanding your assertion that this is a unitary proceeding, wasn't the request, as opposing counsel noted, for attorney's fees from the original litigation, by rule, wasn't that late?
I think by
The
the rule
request,
that he was stating to, it would be. I would concede that.
So if we conclude that the fee award here included an award for the initial proceeding and that was inappropriate, do you agree with the appellant that if the fee calculation was incorrect in that respect, we need a whole redo on the merits? And so it's not, we have to look at the merits of the motion to modify in order to determine whether you were entitled to fees at all?
Not necessarily. So are you saying that we would need to look at the motion to modify itself, not the initial proceeding?
Yeah, let's say our order says, look, the fees, you're not entitled to the fees for the initial proceeding. The award seems to have included that. And therefore, what happens? Do we just remand and there's a calculation subtracting it and that's all that needs to be done? Or do we, because of this mootness issue, or do we need to go back and decide whether there was merit to the, so that there are any fees? Is that issue still live?
I think that the first version of that would be where we go, where there's a potential reduction in the fees.
Well, let me push that a little further. Let's assume, I mean, the protection order in this case has expired. Ordinarily, that would make this moot. However, there is a live issue, it appears, of attorney's fees. And that may take it out of being completely moot because there's still a requirement that attorney's fees be paid. I think the question I would like you to address would be, so with those facts, with an expired PA, we've got two issues, I think, on the attorney's fees. One, whether you were given fees for a proceeding, at least in part, that you should not have been given fees for, even assuming you were going to get an award of fees. But two, whether you should have gotten an award of fees at all. Do we address both of those questions? In other words, because there's a fee award, doesn't that loop us back into having to address the merits of the motion to modify in order to determine whether a fee award was appropriate?
I don't think so necessarily, because I think we're looking at almost two separate orders here. There was the order modifying the protection order, and then there's an order of attorney's fees. And there was,
But don't the order of attorney's fees have to be based on your success on the motion to modify?
potentially, but there was many post-judgment motions filed after our motion to modify requiring responses back and forth.
Well, that may drive up the fees, I get
Right.
that. But the entitlement to fees, isn't that based on prevailing and on the motion to modify? And arguably on the original, but fees weren't sought at that time.
Potentially, but it also could be awarded if there's frivolous motions being filed in a post-judgment basis here as well.
The
Is there-
fee statute reads, and I quote, that the court, I'll read part of the statute. The court can award fees, quote, upon finding that the defendant has committed the harassment alleged, unquote. That's the fee statute. There's no evidence that Mr. Costin committed harassment in connection with the motion to modify, is there?
There was not a violation of the protection order.
Right. So my question is whether if a plaintiff proves harassment initially, does that mean that the plaintiff automatically gets attorney's fees every time there's a modification or an amendment of the order?
I think it would depend on what is filed, and in this case, Mr. Costin filed multiple motions.
Doesn't the statute seem to require that for the attorney's fees to be awarded on a motion to modify, there has to be evidence that the defendant committed harassment that triggered the motion to modify, in other words, violated the protection order in some way?
I don't think so, because I think a party also has a right to ask for attorney's fees when they're responding to frivolous motions that were filed.
In general or statutorily?
In general.
Well, that would be a different basis for attorney's fees you're
It
talking
would be a
about.
different basis for attorney's fees.
Okay, is that the basis upon which the attorney's fees were ordered in this case?
No.
Okay.
If there are no other questions?
There don't appear to
Thank
be.
you.
Your Honor, if I may address a few of those points. Starting with the idea that there was frivolous post-judgment motions, I would turn the court's attention to the appendix to show that there were no post-judgment motions by Mr. Costin. All the motions were by the appellees. So that is incorrect. And also, I'd like to address the statement about Casale, trying to distinguish that case. Now, if I'm mispronouncing Casale, I apologize. I pronounced it as best I can. That was about, it was a divorce case and a protection case, and the court in that case did rely on the divorce case as the prior hearing rather than holding a new evidentiary hearing. But in the holding of that case, as I pointed out before, they said, the law court said that there was no exception. They have not recognized any, this court has not recognized any exception to the requirement that an evidentiary hearing must be held on a motion to modify. So that distinguishment means little when the court itself said there is no exception. Also, I think I might be able to help a little bit with a question of mootness. The question was whether to assess the motion for fees, whether the court could or should go back to the motion to modify. And there's a Supreme Court case, Grupo Mexicano versus Alliance Bond Fund. The court decided, there was a split decision, the court decided 9-0 on this question of mootness, that the court rejected the argument that a controversy over money saves the case from mootness, but does not save the issue of the validity of the, in that case, it was an injunction from mootness. What that's saying is that though it may be moot in terms of whether or not the order is in effect, it does still apply in terms, you still have the ability to go back and review it for the purposes of the fees award.
Thank you,
That's my time.
counsel.
Thank you.
All right, thank you, counsel. Thank you for the argument here today. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. And with that, I think our very first session at the new York Judicial Center is coming to a close.
All rise. All persons having anything further to do before the Honorable Justices of the Supreme Judicial Court, sitting as the law court, may hence depart and give their attendance at Portland at 10:40 tomorrow morning, as this court now stands adjourned. God save the state of Maine and this honorable court.